Super important topic in question, and that is, can a personal representative be removed in the state of Florida? And the answer to the question is yes, but it's important to understand that the standard to remove a personal representative is very high. That's why it's critically important that if you're getting involved in an estate and somebody's petitioned to become a personal representative, if there's some objection to them being the personal representative, that should be presented at the front end. If you sense problem because the sister, the spouse, the whatever has some problems, they should be disqualified based on conflict of interest or other issues. It's important to talk about that and get that on the table first. Now, there's all kinds of case law too that says that even if there's conflict or potential for conflict, if the person's nominated that PR in a will, the preference, the standard is very high to not have that person be appointed at the front end. Standard flips if they become appointed and they engage in misconduct and they need to be removed because of that misconduct. Important thing to understand is that it's not automatic. Well, I talk a lot in these posts about you maybe not need an attorney in some cases for an issue that's serious, like removing a personal representative. That's almost certainly something that you need an attorney to closely examine the facts and understand what those facts are and apply them against the law to determine whether or not that PR is going to get removed. Personal representatives have very specific statutory duties. They're charged with gathering estate assets, determining what debts and liabilities exist, and ultimately distributing those ultimate benefits to the beneficiaries. Each of those things are technically complex, rely on a whole lot of factors. But the conditions under which a personal representative are appointed, even when they're nominated, becomes very problematic and very fact-specific. Can't be convicted of a felony, got to live in state unless they're related, and there's preference if they're not. But 733-504 provides very specific causes for removal of a personal representative, particularly if they've been determined incapacitated. They get convicted of a felony. They fail to comply with court orders. They waste, they embezzle or mismanage estate assets. Conflicts of interest that harm the estate, insolvency, failure to administer it properly, or otherwise being undue or unfit for office. Now, the issues that frequently come up are conflicts of interest. The personal representative is named in a will. She's the wife, and she starts doing things that are contrary to the overall interests of the estate. Kids come in and say, mom or stepmom are acting in interests or in ways that are contrary to the overall estate plans. That's a typical scenario. Fighting these things is very factual specific. So you can't just come in running with the first violation. You got to show that there's a pattern, and obviously building up that pattern and exactly what those circumstances are. Those are the things that are grounds for removal. But let's talk about some specifics and check off the boxes. Taking money without court approval, that's a biggie at the front end. If they're not properly advised by an attorney and somehow they're the personal representative, they've got access to the bank account, they somehow think that continuing to make payments without court authority, particularly when they're payments to themselves or others, that's really problematic. Delaying is another case where clearly they should be removed. And, sometimes this is the PR, sometimes it's the attorney, sometimes it's both. Favoring one beneficiary or the other. So, in a case where, I'm thinking stepmom, whatever, she's got kids, maybe there's some favoritism going on with one beneficiary, that can be a cause for removal. Refusing to provide accountings, refusing to provide communication to any beneficiary. That's something we see pretty frequently. That can be a basis for removal. Other ones, self-dealing or self-interest. That's another biggie. House that she wants to keep because it's the beach house. It's not authorized under the will, not providing for the actual distribution that's required. That is a real problem. Another one is not providing proper notice to creditors and not treating creditors properly, playing games and trying to avoid creditor obligations. That's a direct violation that can lead to an immediate removal. It's governed by Statute 733-504 and Rule 5.430. Problem is, there's not a ton of case law out there. That's with most probate stuff, and that's why one of the things that's really interesting about probates, right, is there's just not a ton of cases out there, so it's super factually specific. But there's another critical point and that is if you can meet the standard to get the person removed. Oftentimes, that takes some doing. You got to look at emails, texts, and basically their actions. Are they moving or not acting properly? There are certain very specific duties about what the personal representative has to do upon removal. 733-301 specifies they got to do a full accounting. They got to account for bad conduct. Oftentimes that's hard, it's like pulling teeth, but there's an explicit statute on the subject. And then Florida Statute 733-609 specifically provides that there is direct liability, fiduciary liability. They can be ordered to repay. Their other share of the estate can be disgorged or removed, and sanctions can be applied. So the statutes that are cited, 733-504, 733-301, and then 733-201 specifies who can petition for those removals. Bottom line is this. Removing a PR is serious business, requires lots of details, lots of facts. I encourage you, if you have an issue like this, reach out, provide the details, get some specifics at the front and some facts, and then like and subscribe to the page if there's additional information that's required.